Today we address the dreaded paragraph 9 of qualified assignments. When I say dreaded, I'm talking about, really not saying, I don't really mean dreaded, but it's a paragraph that is from time to time and is worrisome to people who are not familiar with structured settlements, particularly attorneys who are reviewing the document for defendants or defendants insurance companies. And typically what the paragraph says is it addresses what happens if Section 130C has not been satisfied. And the consequences of it not being satisfied is it gives the qualified assignee the ability to unwind the assignment and transfer the qualified funding asset, the annuity, back to the defendant or the defendant's insurance company, which will then have the liability. Now this is something that is not usually something that's going to warm the cockles of the hearts of any defense attorney or insurance adjuster who just want to, they enter into a structured settlement, they want to be assured that that's it, it's done. So I can understand why it would make somebody uneasy. But I submit to you that if you retain a qualified structured settlement expert, reviews these documents, and takes a look, you're really not going to have anything to worry about because you will have qualified under Section 130C. There's basically 4 separate criteria that you need to do to qualify for Section 130C. Let me enumerate them for you. So the first thing is that the payments that are being assigned have to represent damages on account of personal injury, personal sickness, or workers' compensation. With respect to the personal injury or personal sickness, it has to be a physical injury or physical sickness. The assignment has to be from a party to a suit or agreement. To a suit is parties to a lawsuit, and parties to an agreement, it could be a claim that has actually not been placed into suit. Furthermore, the payments cannot be the payments must be fixed and determinable, and they cannot be increased or decreased or accelerated or deferred. And that obviously is part of the settlement agreement. In addition to that, the assignee's obligation cannot be greater than the party that is assigning the obligation. And lastly, the periodic payments have to be excludable from gross income as defined in Section 104A2 for physical injury or physical sickness, or 104A1 if you're dealing with a workers' compensation case. So those are the specific criteria that you need to satisfy with reference to Section 130C. So if you satisfy all those criteria, then paragraph 9 should not be really be an issue. So while there are inherent dangers for both plaintiffs and defendants if paragraph 130C is not satisfied, if the criteria are followed and the process is carefully reviewed by people who are structured settlement experts, then there should be no problem with complying with Section 130C. If you have any questions, please contact me, John Darer, at forstructures.com. My toll-free number is 888-325-8640. Thank you very much. Have a great day.